We will now proceed under the 5-minute rule with questions, and I recognize myself for 5 minutes of questioning. Mr. Crampton, I take it you represent Mr. Vaughn. I've had occasion to look at the Sixth Circuit's opinion, or a panel's opinion there from November 24. Hang on one second. There we go. On, I guess, an application to stay his sentence, and it, of course, went against you, Mr. Vaughn, but I find this piece to be very interesting at the heart of what I believe to be the issue here. It says that you presented a study by the Crime Prevention Research Center which identified 135 attacks on pro-life churches and pregnancy resource centers compared to only 6 attacks on abortion clinics since the date of Dobbs, and that Mr. Vaughn's argument to the court was that under the FACE Act, the Department of Justice has prosecuted only 2 people under the FACE Act for attacking pregnancy resource centers, while prosecuting 26 pro-life activists under the same statute. And here's where it gets very interesting, having just read this. It says, but most of the incidents in the CPRC study appear to allege vandalism in potential violation of one subsection of the FACE Act, rather than obstruction in violation of another subsection, which is what Vaughn was prosecuted for. And the government could exercise its discretion to prosecute obstruction rather than vandalism without violating the Equal Protection Clause. Now, as I just ran across that, I've been practicing law a long time. Well, I practiced till I got here. And that may, I guess I get the distinction being drawn, but when you consider that vandalism against pregnancy resource centers usually, almost always itself, is conveying a threat of force for people who may subscribe to the services of that clinic, there's no distinction whatsoever between those acts. And for the Department of Justice to exercise discretion to prosecute one and not the other, based apparently on the ideology of the person who's engaged in those acts, I can't think of anything that seems to be more of an example of selective prosecution the Constitution would not abide. So that's a stunning. What about that, Mr. Crampton? Do I have that wrong?
I think you have that exactly right, Mr. Congressman. The further distinction is, as you suggest, I would argue the vandalism actions are of a more serious nature than a sit-in. Moreover, they were more recent. Mr. Vaughn's actions took place in 2021. Those acts of vandalism took place in 2023 and 2024. So it's a very puzzling distinction that the court drew there.
To Professor Waters' point, I do not disagree that we don't want people engaged in violence around abortion clinics or pregnancy resource centers. It should be condemned and it should be punished appropriately. But I just wonder, Professor Waters, when you see these things where SWAT teams are going out to the homes of people because they've engaged in a nonviolent act of what I understand alleged here is a conspiracy to block access for an hour that denied one patient and one employee access, it just seems to me troubling that you got guns drawn and pointed at a man's head and his children arrested in the side yard or stopped in the side. Doesn't that seem, I mean, we're in an environment where we're always talking about police officers should de-escalate in the context of, what justifies that, Professor Waters? Does that disturb you?
Thank you for the question. So, I will say as a human, listening to Mr. Vaughn speak, it sounds like that was a terrifying day, and I'm not going to dispute his experience of that. I do not work for the DOJ. I am not involved in prosecutions brought by the DOJ.
And I'm not trying to make you assign responsibility. I'm just asking for a simple, are there things we can agree on? And it seems to me that, and I'll just leave it at this, Professor Waters, it just seems, because I think it's a very simple thing. I don't understand, and we've seen it in so many ways. It is the fundamental part of this weaponization, and I was going to yield all my time to Mr. Biggs, but I got carried away. The American people see these incidents when they seem to be made for CNN, when people of certain political persuasions or ideas are targeted, the SWAT team goes out and raids them in their homes, and it's totally disproportionate. That must stop. And I'll guarantee you it is going to stop in the next administration. Got 15 seconds for you, Mr. Biggs.
Thank you, Mr. Chairman. So for that reason, I won't even engage in a diatribe or ask questions, but I will ask that the May 5th, 1994 congressional record from the House, page 9409, Mr. DeLay's speech about this, the FACE Act passage, be admitted to the record.
With my apologies and without objection, so ordered, and I now